All right, y'all, it is day 12 of the Sam Bankman-Fried trial. Today we got testimony from Can Sun, who was the general counsel of FTX. So this was interesting, and we heard about a very inauspicious conversation that Can Sun, the general counsel, had with Sam, in which Sam asked Can to come up with legal justifications for the illegal shit that he had done. So I will tell you all about how that conversation went and ended and where it went from there. It's kind of interesting. And then we also heard today from Bob, I do not know how to pronounce his last name, Bob Borgerdi, who was the managing director at Third Point Ventures, which is a venture fund that invested in FTX, and we'll talk briefly about what came out there. Before we dive into today's episode, I do need to give a huge shout out and thanks to OpenSea, Ledger, and Web3 Cents, who are our sponsors. You can go ahead and check out their stuff in the show notes below. Give them some support as they support me. And with that, I want to get right into today's show. Okay, so first up on the stand, as I mentioned, was Can Sun. He was the general counsel for FTX. He joined in August of 2021 and was general counsel right through November of 2022 when he resigned because they were defrauding customers out of $8 billion. And when he joined, one of the first things it seems he worked on was an update to the FTX terms of service. That's right, we finally got to look at the FTX terms of service. This is something I've been seeing a lot of chatter about, somewhat in the comments, just online. It was kind of strange. I felt like that we hadn't actually looked at the terms of service yet, but we finally did today. So here's what you need to know. There was an update to the terms of service that was completed around September of 2021, but that didn't go live until May of 2022. And one of the provisions that was added as part of that was very explicit language stating that digital assets were kept safe, that when you deposited digital assets to FTX, they were yours. I'm going to read out some of the specific language, but basically saying everything that we intuitively felt to be true, which is like your money deposited on the exchange was yours and was not allowed to be touched according to the terms of service by FTX. So some specific language here. It says, the terms of service said things like the title to your digital asset will at all times remain with you and will not be transferred to FTX trading. It said none of your digital assets in your account are the property of or shall or may be loaned to FTX trading. You control the digital assets in your account at any time you may withdraw your assets. These were things that were said in the terms of service. Now, notably, this is about digital assets, which is distinct from fiat. This is something that the defense brought up a bit in their cross-examination, which is there was a separate section detailing things about fiat, and it actually wasn't explicit that when you deposited your fiat, it remained yours, which I thought was a little interesting. What Can Sun testified to, though, was that his understanding and the general understanding was clearly that any money you deposited remained yours and wasn't to be used by FTX, etc. And that was what had been represented by Sam and by others. And we do have some other language that we looked at today that came from a document. This one was the FTX Digital Markets Safeguarding of Assets and Digital Token Management document, which I believe is something that was put together as they were trying to get some regulatory approval for things in the Bahamas and in the US. And Can Sun testified that this was available to users of the platform if asked. So they had some institutional investors or others ask for something more specific or more detailed or whatever. And this was provided to customers in addition to other folks. Here are some things that were said in this document. It says, FTX Digital Markets. So this document is specifically relating to FTX Digital Markets, which was a subsidiary of FTX Trading. It was like the Bahamas subsidiary, but it contained a lot of the infrastructure and payment infrastructure and stuff that powered FTX. It was wholly owned by FTX Trading, which is what Sam owned the majority of, but it was technically a separate entity within FTX. So FDM is what I'll abbreviate it to, which stands for FTX Digital Markets. FDM emphasizes their stringent commitment to safeguarding customer assets. FDM is ultimately responsible for the safeguarding of its customer assets. FDM has the responsibility to ensure segregation of customer assets from FDM assets. And this was an interesting one. Customer assets will be appropriately ring-fenced. This came up several times in this document. They used the term ring-fenced. And Can Sun testified that that meant they would be kept in separate accounts from FTX's own assets, such that if FTX or FDM went bankrupt, the customer assets would still be safe and customers could still get their money back. Womp womp. Because FTX did go bankrupt, in case you didn't hear, and customers have not all gotten their money back by any means. So that was some of what we looked at that clearly we were looking at because it ran completely counter to how the exchange was actually running. So it's clearly just wild misrepresentations. We also looked at the margin trading policy within the terms of service because this is where there were provisions where like money could be taken from your account if you were opted into margin trading and doing certain specific things, on leverage and with margin. In fact, we looked at specifically that there was a provision around clawbacks, which is interesting because this is something that Sam had repeatedly said FTX never did. We've talked about this a little bit before, clawbacks being a system that apparently is common among exchanges or crypto exchanges where traders who are trading on margin who need to be liquidated, basically their losses can be socialized among a bunch of traders that have actually made money and been profitable. And so part of the profits of other traders can get clawed back. And what's so interesting is Sam was always so adamant that they didn't do clawbacks because they had this insurance fund, which we've talked about on the show before. And they had these backstop liquidity providers, which we've talked about on the show before. And so they had this risk waterfall where basically the BLPs were like the first line of defense in a situation where somebody was losing a lot of money. And then the insurance fund was the second line of defense. And then the absolute last line of defense here was the clawback piece. But Sam would verbally say all the time, we don't do clawbacks. We never do clawbacks. But we did see that there was the possibility for clawbacks in this margin trading section of the document. What's so funny about this is like Sam was so adamant they didn't do clawbacks, obviously because it sounds like it's much better for customers if your money can't be at risk, if you're profitable and you can't be at risk for having any of those profits taken away. That obviously makes you feel better as a customer. And then this dude is out there literally just putting your money into Anthropic, taking the most risks with your money of anybody, of any of the exchanges. I mean, I guess we don't know that for sure. Who knows what CZ actually does with customer money, but oh my God. Anyway, then we talked a little bit about how in August or September of 2022, Can Sun learned about some of the special privileges that Alameda had. So that was about a year into his tenure at FTX. And he was really upset. He learned basically that Alameda was exempt from auto liquidation and they were the only customer on the exchange that had that exemption. And so he immediately demanded that changes be made. A plan was put in place where Alameda would just have like delays to their liquidation. So it wouldn't be like they couldn't get auto liquidated at all. There would just be delays to it. And Can Sun insisted that they then inform regulators about that policy and that all other large market makers on the exchange get that same policy applied to them. Now, Can says he did everything he needed to on the legal side to get all of that in place, but that it was then passed off to the business team to actually execute and implement. And as far as he knows, it was never executed or implemented. Now, to be fair, FTX blew up 2 months after these conversations or 3 months after this was discovered and after Can made these demands. So it wasn't like a ton of time to actually make the changes, but obviously it also seems somewhat likely that the changes never would have been made because that was actually just the tip of the iceberg for the problems when it came to Alameda and FTX, which Can did not learn about until November of 2022, which brings us to what was by far the most interesting part of the testimony today. November of 2022, everything is starting to implode. In early November, Can was on a call with Ramnik Arora, who was like, I think his title was technically head of products, but he was really like head of finance. He did a lot of the investment stuff with Sam, like communicating with investors. So Ramnik Arora and Can Sun were on a call with Apollo, who they were having a conversation with about potentially investing and specifically about getting basically emergency funding from as things were starting to blow up. And Apollo asked for financial statements from FTX, which Can Sun and Ramnik didn't have. So they then told Sam, and I assume, I don't know exactly the time frame here, but a few hours later, Sam provides Can with financial statements to be sent to Apollo. And this is where Can testified that he received these financial statements. He was reviewing them in a room with Sam, Nishad, Ramnik Arora, and Joe Bankman, interestingly. And he says that was when he started to realize, oh my gosh, like we've used customer money. He was reading these financial statements being like, this doesn't make any sense. There's this $7 billion hole. Where did this come from? He said he would ask questions about specific line items or ask for more details, and he would either get no answer or he would get these very vague answers. And he was like, oh my gosh. And that's when it really hit him. It's been interesting hearing from different employees and learning when it first hit them, what was going on, like when they first found out. Like Nishad found out in September, a couple months before Can did, and it was like, oh my God, what? So Can finds that out, sends the spreadsheets on to Apollo. And a few hours later, Sam approaches him and says, hey, Apollo has gotten back to us and they're asking for the legal justification for the money that's missing. So I need you to come up with a legal justification for why the money is missing. And Can obviously didn't say exactly this in court, but was essentially like, what the fuck? What do you mean? Like, what is the actual reason the money is missing? Like, why is this money missing, Sam? And of course, Sam didn't have an answer to that. So a few hours later, Sam and Can go for a walk around their luxury Bahamas apartment. They're walking around the building, apparently. And Can is like, yeah, dude, there's no legal justification for this. There are some theoretical reasons, some theoretical justifications for why we could have used customer money, but none of them stack up to the reality. And he proceeds to tell him the theoretical justifications, which were, number one, if there had been a prolonged period where FTX couldn't reach a customer and they were inactive on the exchange, theoretically, FTX could charge a dormancy fee to that customer. Of course, they did not have nearly enough large inactive customers on the exchange to justify an $8 billion hole. It's weird because they kept saying $7 billion today in court, which is why I think I've said it before, but $8 billion was what was missing to customers. I mean, it doesn't really matter to me if it's 7 or 8 billion, but that was kind of a strange thing that they kept saying 7 billion today. I'm going to use them interchangeably for the sake of this episode. So that was the first reason. And he was like, but that doesn't check out at all. Like, clearly that doesn't work. The second theoretical justification is that they have this borrow lend program, which is part of this margin trading program. So if a user volunteers to lend money to other users and they default, that could be a reason to take their money. Or when they put up collateral as part of the margin program, they're pledging assets. And so collateral they put up could obviously be taken away. But he had apparently had gone to Nishad and maybe Nishad and somebody else and asked them to pull records around how many people were participating in the spot margin program. And it, as we'd heard in previous testimony, it does not nearly cover all of the assets that were missing. So once again, he told Sam, like, this is theoretically a reason, but it does not actually hold up at all. And Can Sun testified that Sam acknowledged that. He was like, yep, according to Can Sun, and said he understood that. And then finally, this one, Can said that some exchanges don't make it clear what the relationship is between the customer and the money they deposit once they've deposited money onto the exchange. Basically saying, in theory, there are crypto exchanges that could take that money and say, hey, we never said we weren't going to take the money. But that was not the case in FTX because Can Sun had written these nice buttoned up terms of service, or had helped to write these nice buttoned up terms of service that went live in May of 2022 after Can was hired as general counsel, because he thought that this is how they were operating. He thought they were on the up and up. So he's like, I didn't think there were any problems with the nice up and up terms and service that I wrote. Of course, he didn't actually say that in court, but I'm imagining that's what he's thinking. And so anyway, so then he says, look, that would be the third reason, but that also doesn't hold up here. And he said that Sam, again, acknowledged this, and Sam seemed very unsurprised by hearing all of this. So clearly, like, none of this was particularly news to him, was Can's impression. Can also testified that he went for a walk with Nishad, who seemed very nervous about everything. Can testified that during the group meeting they had all had, he described Nishad as looking like his soul had been plucked from his body. He said Nishad was very pale. He looked like almost gray, like he was not doing well. And that he looked like his soul had been plucked from his body. And I know I shouldn't feel too bad for these people who did defraud all these customers, but my heart really goes out to Nishad, who didn't know about this until 2 months before it all blew up, and then says he stuck around because he wanted to try and fix it. And he figured if he was there, that was the best shot at fixing it and making customers whole. And just by every account, this was somebody who felt really, really guilty about everything that was going on. Okay. In any case, Can Sun proceeds to resign the following day and goes off. Now, what is interesting is we were then in court played a clip from Sam Bankman-Fried, Sam getting interviewed by George Stephanopoulos on Good Morning America. And I don't know if folks remember this or have seen this, but it is so cringy and uncomfortable. So George points out the terms of service to Sam and is like, what you said you weren't going to take their money, and then it seems like you took their money. And Sam is very wishy-washy and is like, and just seems like he doesn't know what he's talking about. And then he's like, we did have this borrow-lend program. And Can testified, yes, that's one of the things I talked to him about as this theoretical explanation that didn't actually make sense. So I'm just imagining Sam having his general counsel tell him, yeah, there's this theoretical thing that does not apply at all in this case. And Sam's brain being like, dope. That's the thing I'm going to say on national television to George Stephanopoulos and many millions of people. We're going to go with that one, that thing that definitely does not stack up at all to the reality of the situation, according to my own general counsel. Like, what was he thinking going on this media tour? Like, we now played that in court. It makes him look guiltier to the jury. Whatever. I'm never going to fully understand the rationale to these things. But in any case, that was Can Sun's testimony. And then we did also, as I mentioned, hear from Bob Borragherdi today, whose last name I still don't know how to pronounce. And he was the managing director at Third Point Ventures. As I mentioned, his testimony was pretty brief. He basically talked about how he had several calls, or at least one call that he had been on with Sam prior to investing. They invested about $60 million with FTX. And that they had, as part of those conversations, talked about the risk engine at FTX and how it was so unique and special. This was part of that thing I described with like the BLPs and the insurance fund, and also it was like automated in certain ways, and it was supposed to prevent there from being any sort of biasy because it was automated as opposed to being run by a human. But of course, not disclosed to them was the fact that Alameda in the code was coded to have special privileges. So yeah, a code was running this thing, but when you code in special privileges, you're still bringing in human bias to the thing. So he testified that he was not told that Alameda had special privileges, but that they did talk a lot about the risk engine and how, in theory, nobody was supposed to have special privileges because of the risk engine. And they also talked about the Alameda relationship with FTX more broadly, and they were told that Alameda was kept at arm's length and these were two separate businesses and blah, 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 all the usual stuff that we've heard Sam has said many times, apparently. And of course, he then testified that had he known the reality of the situation, had he known that Alameda was given a special privilege within the risk engine system and that they were very intertwined, they would not have invested, and they would have not therefore lost their $60 million. So that was that. The cross-examination lasted all of about maybe 5 minutes. It was so quick. The defense counsel got up there, asked some question about, were you aware that related parties could convert? Well, I didn't even understand it. I was trying to write it down and I still didn't understand it. And the witness clearly didn't understand it. And he's like, I don't know what you're talking about. Like, I was aware that there were banks like Signature that would, be involved in converting to stable coins and blah, blah, blah. And the defense counsel was like, that's not what I'm talking about. And the witness was like, I don't know what you're talking about. And I think the goal was just to make it look like the witness was confused by something and hadn't done proper due diligence, and I guess therefore hadn't really been defrauded because it was just that they didn't understand things. I don't know. In any case, it lasted, like I said, maybe 5 minutes. And then that was the day. Just those two. Court ended at 1 today. So we will be back next week. The court is out of session until next Thursday, but I am going to probably publish some extra little bonus things next week because there's been so much to this trial and I can't dive into all of it every day. So I'll probably put out some bonus pieces just diving into other parts of people's testimony that I think are interesting or worth knowing about. So hopefully y'all enjoy those. And I really appreciate all of the likes and comments and subscriptions, and please keep that going. I love reading your comments. And with that, thank y'all so much. I'll see you next week.